Hello everyone, welcome to the Literary and Jury Charge for the 170 class. We're going to start out with a segment from Don't Sweat the Small Stuff. This is called Surrender to the Fact That Life Isn't Fair. Ready? A friend of mine, in response to a conversation we were having about the injustices of life, asked me the question, who said life was going to be fair, or that it was even meant to be fair? Her question was a good one. It reminded me of something I was taught as a youngster. Life isn't fair. It's a bummer, but it's absolutely true. Ironically, recognizing the sobering fact can be a very liberating insight. One of the mistakes many of us make is that we feel sorry for ourselves or for others, thinking that life should be fair, or that someday it will be. It's not, and it won't. When we make this mistake, we tend to spend a lot of time wallowing and or complaining about what's wrong with life. We commiserate with others, discussing the injustices of life. It's not fair, we complain, not realizing that perhaps it was never intended to be. One of the nice things about surrendering to the fact that life isn't fair is that it keeps us from feeling sorry for ourselves by encouraging us to do the very best we can with what we have. We know it's not life's job to make everything perfect. It's our own challenge. Surrendering to this fact also keeps us from feeling sorry for others because we are reminded that everyone is dealt a different hand and everyone has unique strengths and challenges. This insight has helped me to deal with the problems of raising two children, the difficult decisions I've had to make about who to help and who I can't help, as well as with my own personal struggles during those times that I have felt victimized or unfairly treated. It almost always wakes me up to reality and puts me back on track. The fact that life isn't fair doesn't mean we shouldn't do everything in our power to improve our own lives or the world as a whole. To the contrary, it suggests that we should. When we don't recognize or admit that life isn't fair, we tend to feel pity for others and for ourselves. Pity, of course, is a self-defeating emotion that does nothing for anyone except to make everyone feel worse than they already do. When we do recognize that life isn't fair, however, we feel compassion for others and for ourselves. And compassion is a heartfelt emotion that delivers loving kindness to everyone it touches. The next time you find yourself thinking about the injustices of the world, try reminding yourself of this very basic fact. You may be surprised that it can nudge you out of self-pity and into helpful action. Okay. Got some jury charge for you. This is on evaluating testimony. Ready? Ladies and gentlemen, upon the issues here joined, the burden rests upon the plaintiff of proving all the material allegations of the complaint by a fair preponderance of the evidence. By preponderance of the evidence is meant the greater weight of the evidence, the greater force with which the evidence on one side or the other appeals to your minds. But if the party having the burden in this case has satisfied you of the truth of his or her contention in that regard, he or she has sustained such issue by a fair preponderance of the evidence. If the evidence is evenly balanced for and against any particular fact in issue, then your finding upon such fact should be against the party having the burden of proof in that regard, since he or she has failed to prove the same by a fair preponderance of the evidence. If you believe from the evidence that any witness has testified falsely, intending thereby to deceive or mislead you as to any material fact or facts in the case, then you have a right to disbelieve the testimony of such witness except so far as such testimony is corroborated by other credible testimony. This is a civil case, and you are the exclusive judges of the weight of the evidence and the credibility of the witnesses. In determining the weight you will give to the evidence of any witness, you have a right to take into consideration the demeanor of such witness on the stand, his or her candor and sincerity in testifying, or the lack of the same, his or her interest or lack of interest in the outcome of the suit, his or her knowledge or lack of knowledge concerning the facts about which he or she has testified, his or her prejudice or bias, if any, is shown, his or her relationship, if any, to either party to the suit, and such other facts and circumstances disclosed by the evidence as will assist you in determining the weight you should give to the evidence in the case. Neither by these instructions nor by any words uttered or remark made by the court during this trial does or did the court intimate or mean to give or wish to be understood as giving an opinion as to what the proof is or what it is not, or what the facts are in this case, or what are not the facts therein. It is solely and exclusively for the jury to find and determine the facts, and this they must do from the evidence. Having done so, they apply to them the law as stated in these instructions. The instructions to the jury are and constitute one connected body and series, and should be so regarded and treated by the jury. That is to say, they should apply them to the facts as a whole, and not detach or separate any one instruction from any of the others. Okay, I have some land description for you. Here we go. Ready? I'm going to read this twice. Ready? All that portion of lot number 50, first concession, township of Yucaipa West, being a strip of land 100 feet in width and 75 feet measured perpendicularly from a center line, which center line may be located as follows, commencing at a point in the south limit of said lot 50, distance 1,225.53 feet, measured north 71 degrees 35 minutes, west along the south limit from the southeast angle of lot 50 aforesaid, thence north 32 degrees 15 minutes west 278.23 feet, thence north 33 degrees 53 minutes west 774.30 feet, thence north 34 degrees 19 minutes west 38.93 feet, more or less, to the north limit of said lot number 50. Okay, now I'm going to read this one more time. Ready? Same speed. All that portion of lot number 50, first concession, township of Yucaipa West, being a strip of land 150 feet in width and 75 feet measured perpendicularly from a center line, which center line may be located as follows, commencing at a point in the south limit of said lot 50, distance 1,225.53 feet, measured north 71 degrees 35 minutes west along the south limit from the southeast angle of lot 50 aforesaid, thence north 32 degrees 15 minutes west 278.23 feet, thence north 33 degrees 53 minutes west 774.30 feet, thence north 34 degrees 19 minutes west 38.93 feet, more or less, to the north limit of said lot number 50. Okay. My next article for you is called Medal of Honor. Ready? Mr. President, today I am reintroducing a bill on behalf of myself and my colleague Howard Davis that will direct the Army Board for Correction of Military Records to reconsider the application of Mr. Lawrence R. Matthews of Lubbock, Texas, for consideration for the Congressional Medal of Honor. In determining his eligibility, the board should apply the standards for such an award that were in effect on July 27, 1941. Actually, our bill is identical to legislation that was introduced 2 years ago. We are interested in Mr. Matthews' unusual predicament and would like to assist him. Mr. Matthews is a World War II military hero. Since 1941, he has continued his struggle to receive the Congressional Medal of Honor. He was recommended for the medal by his commanding officer after distinguishing himself in the battle against the Germans and in the capture of Hitler, including the Operation Queen. It is our belief that if Mr. Matthews is judged by the criteria that were in effect at the time he was recommended for the Congressional Medal of Honor, he would have qualified. The legislation we propose is that Mr. Matthews be considered for the medal under the criteria in effect in 1941. Mr. Matthews has suffered many disappointments in his elusive quest for the Congressional Medal of Honor. Yet after all these disappointments, he remains a courageous and loyal American who believes in liberty and the democratic society. This is our opportunity to honor a truly outstanding American whose spirit and tenacity are undying. Mr. President, I ask that the bill be printed in the record. There being no objection, the bill will be printed in the record. Okay. Got some expert opinion. Here we go. Your Honor, if I may, I would like to read into the record Dr. Lane's report. I examined Brian Crandall in my office on July 24, 2003. This patient is a 20-year-old pipe fitter who had worked at Hillshire Brothers Incorporated, started in May of 2003. His last day of work there was October 7, 2002, which was the date of his injury. In this man's work, he sets a power drill into a freestanding machine. He will then run fiberglass through a resin, the resin in the past being polyester, but being more recently epoxy resin. The resin has caused the patient problems. The epoxy gave him a good deal of nasal problems and some respiratory problems. The polyester made him dizzy and nauseated. As he was working on October 7, 2002, his right hand caught on the drill and was crushed. The patient was taken to the Cleveland Community Hospital, where he was kept for 11 days due to complications. He understands that he sustained fractures above his wrist. A plate was put into his wrist, and the wrist is now very tender. He returned to Ohio General Hospital 2 weeks ago so that the plate could be removed. The sutures are still in place. While the patient worked, he frequently inhaled the dust of fiberglass. It bothered him a good deal, and the patient began coughing. His nose would often bleed, and he became short of breath with exercise. The patient recalled that one of the chemicals he worked with, he can name 4, polyester in its resinous form, methylene chloride, epoxy resin, and a material he calls gel coat. The patient has smoked about half a package of cigarettes a day for 3 years, leading up to 1.5 packs a day. The blood pressure is 110/80. The chest is negative. The right hand has limited mobility. The abdomen is negative. The chest is clear. The lateral view of the chest is within normal limits. The anterior-posterior view of the chest shows some increase in marking, suggestive of a mild bronchitis, but no other abnormalities. The patient did not work at this job very long. The damage that has been caused suggests that the patient probably has not yet developed a working disability. However, in the future, he should no longer work with plastics. Okay. go back to jury charge. The subject here is interpretation of state law. Okay, here we go. I agree that the state action was probably enjoined, and so I concur in the opinion of the court to that extent, but I dissent from the direction to the district court to hold the case while the parties repair to the state court to get an interpretation of the Louisiana statute around which this litigation turns. That procedure is advisable where private parties question the constitutionality of a statute or state statute. An authoritative construction of the state law may avoid the constitutional issue or put it in new perspective. Under Section 1331, the federal district court has jurisdiction where the matter in controversy exceeds the jurisdictional amount and arises under the Constitution, laws, or treaties of the United States. In litigation in the federal courts under that statute, the necessity of constructing state law arises because of the federal court's duty to avoid, if possible, a federal constitutional question. Here, although potential constitutional questions may lurk in the background, this litigation primarily concerns title to land claimed by the United States. It is litigation which Congress, by sections 1345 and 1346, has entrusted to the federal district court. Those sections allow civil litigation of the United States to be conducted in the federal courts. In that situation, it is the duty of the federal court to decide all issues in the case, those turning on state law as well as those turning on federal law. In Raymond versus Clark, a case in the federal courts by reason of diversity and citizenship, we refused to remit the parties to the state court for a decision of difficult state law questions. We held that it was the duty of the federal court to decide all issues in the case, state or federal, difficult or easy. There have been exceptions to this policy, notably in bankruptcy proceedings, where trustees are sometimes sent into state courts to obtain adjudications on local law questions pertinent to the administration of the bankrupt's estate. It is peculiarly in the inappropriate way to follow that this course here suggests Congress has decided that the United States should have the benefit of the protection of its own courts in this type of litigation. We properly hold that the federal court, not the state court, has jurisdiction of the controversy, but we beat the devil around the bush when, having taken the litigation out of the state court, we send the parties back to the state court for its instruction of Louisiana law, which is the only or the most significant issue in the case. The problem is not only to construe the state statute, but to construe its constitutionality. The federal courts can make that construction as readily as the state court. That is the congressional scheme, and we should not change it by judicial fiat. All right. Got about a half more minute. I'm going to read a little bit from A Living Dream. Mr. Speaker, for several years now, my hometown, the city of Santa Barbara, California, has been organizing and leading a campaign called A Living Dream. This campaign is aimed at encouraging and stimulating community service and pride and promoting the city's economic goals. Not surprising, the campaign is effective, exciting, and widely supported. On February 11, 2011, the citizens of Santa Barbara had the chance of a lifetime to show that actions do speak louder than words. I am proud to report that citizens supporting A Living Dream were able to muster mass support and recognition when a potentially volatile situation developed. In a broad demonstration of community pride and unity, Santa Barbara was the scene of the dedication of the Ronald Reagan Library. During these dedication ceremonies, nearly 50 Vietnam veterans stormed on the assemblage, chanting anti-nuclear slogans, harassing the police officers, and attempting to cause total chaos and confusion. A great deal of credit goes to the chairperson of A Living Dream. Without so much as a wave of the hand, the dedication ceremonies were halted, and the chairperson approached the leader of the Vietnam veterans and shook his hand and thanked him for coming to the dedication ceremonies. The chairperson encouraged the veterans to join in the truly worthwhile cause of working with their adversaries rather than against them. The veterans were invited to stay for the dedication ceremonies. As you can see, the city of Santa Barbara contains some truly enlightened community leaders, a highly professional police force, and a group of caring and reasonable citizens. By positive actions, a potentially explosive situation was avoided. The city of Santa Barbara reinforcing the meaning of the right to peaceful assemblage and the right to free speech. Okay, that concludes our literary and jury charge for the 170 class. Have a great day.